Civil Code of the Philippines, Chapter 3, Quieting of Title, Article 476. Whenever there is a cloud on title to real property or any interest therein, by reason of any instrument, record, claim, encumbrance, or proceeding, which is apparently valid and effective, it is but is in truth and in fact invalid, ineffective, voidable, and unenforceable, and may be prejudicial to said title, an action may be brought to remove such cloud or to quiet the title. An action may also be brought to prevent a cloud from being cast upon title to real property or any instrument. Article 477. The plaintiff must have legal or equitable title to or interest in the real property which is the subject matter of the action. He need not be in possession of said property. Article 478. There may also be an action to quiet title or remove a cloud therefrom when the contract, instrument, or other obligation has been extinguished or has terminated, or has been barred by extinctive prescription. Article 479. The plaintiff must return to the defendant all benefits he may have received from the latter, or reimburse him for expenses that may have redounded to the plaintiff's benefit. Article 480. The principles of the general law on the quieting of title are hereby adopted insofar as they are not in conflict with this code. Article 481. The procedure for the quieting of title or the removal of a cloud therefrom shall be governed by such rules of court as the Supreme Court shall promulgate. Chapter 4. Ruinous building and trees in danger of falling. Article 482. If a building, wall, column, or any other construction is in danger of falling, the owner shall be obliged to demolish it or to execute the necessary work in order to prevent it from falling. If the proprietor does not comply with this obligation, the administrative authorities may order the demolition of the structure at the expense of the owner or take measures to ensure public safety. Article 483. Whenever a large tree threatens to fall in such a way as to cause damage to the land or tenement. Kami. Take a bat. Article 483. Whenever a large tree threatens to fall in such a way as to cause damage to the land or tenement of another or to travelers over a public or private road, the owner of the tree shall be obliged to fell and remove it, and should he not do so, it shall be done at his expense by order of the administrative authorities. Title 3, Co-Ownership. Article 484. Article 484. There is co-ownership whenever the ownership of an undivided thing or rights belongs to different persons. In default of contracts or special provisions, co-ownership shall be governed by the provisions of this title. Article 485. The share of the co-owners in the benefits as well as the charges shall be proportional to their respective interests. Any stipulations in a contract to the contrary shall be void. The portions belonging to the co-owners in the co-ownership shall be presumed equal unless the contrary is proved. Article 486. Each co-owner may use the thing owned in common, provided he does so in accordance with the purpose for which it is intended, and in such a way as not to injure the interests of the co-ownership or prevent the other co-owners from using it according to their rights. The purpose of the co-ownership may be changed by agreement express or implied. Article 487. Any one of the co-owners may bring an action in ejectment. Article 488. Each co-owner shall have a right to compel the other co-owners to contribute to the expenses of the preservation of the thing or right owned in common and to the taxes. Any one of the latter may exempt himself from this obligation by renouncing so much of his undivided interest as may be equivalent to his share of the expenses and taxes. No such waiver shall be made if it's prejudicial to the co-ownership. Article 489. Repairs for preservation may be made at the will of one of the co-owners, but he must, if practicable, first notify his co-owners of the necessity for such repairs. Expenses to improve or embellish the thing shall be decided upon the majority as determined in Article 492. Article 490. Whenever the different stories of a house belong to different owners, if the titles of the ownership do not specify the terms under which they should contribute to the necessary expenses, and there exists no agreement on the subject, the following rules shall be observed. 1. The main and party walls, the roof, and the other things used in common shall be preserved at the expense of all the owners in proportion to the value of the story belonging to each. 2. Each owner shall bear the cost of maintaining the floor of his story, the floor of the entrance, front door, common yard, and sanitary work common to all, shall be maintained at the expense of all the owners pro rata. 3. The stairs from the entrance to the first story shall be maintained at the expense of all owners pro rata, with the exemption of the owner of the ground floor. The stairs from first to the second story shall be preserved at the expense of all, except the owner of the ground floor and the owner of the first story, and so on successively. Article 491. None of the co-owners shall, without the consent of the others, make alterations in the thing owned in common, even though benefits for all would result therefrom. However, if the withholding of the consent by one or more of the co-owners is clearly prejudicial to the common interest, the courts may afford adequate relief. Article 492. For the administration and better enjoyment of the thing owned in common, the resolutions of the majority of the co-owners shall be binding. There shall be no majority unless the resolution is approved by the co-owners who represent the controlling interest in the object of the co-ownership. Should there be no majority, or should the resolution of the majority be seriously prejudicial to those interested in the property owned in common, the court, at the instance of the interested party, shall order such measures as it may deem proper, including the appointment of an administrator. Whenever a part of the thing belongs exclusively to one of the co-owners and the remainder is owned in common, the preceding provisions shall apply only to the part owned in common. Article 493. Each co-owner shall have the full ownership of his part and of the fruits and benefits pertaining thereto, and he may therefore alienate, assign, or mortgage it, and even substitute another person in its enjoyment, except when personal rights are involved. But the effect of the alienation or the mortgage with respect to the co-owners shall be limited to the portion which may be allotted to him in the division upon the termination of the co-ownership. Article 494. No co-owner shall be obliged to remain in the co-ownership Each co-owner may demand at any time the partition of the thing owned in common, insofar as his share is concerned. Nevertheless, an agreement to keep the thing undivided for a certain period of time not exceeding 10 years shall be valid. This term may be extended by the new agreement. A donor or testator may prohibit partition for a period which shall not exceed 20 years. Neither shall there be any partition when it is prohibited by law. No prescription shall run in favor of a co-owner or co-heir against his co-owners or co-heirs so long as he expressly or impliedly recognize the co-ownership. Article 495. Notwithstanding the provisions of the preceding article, the co-owners cannot demand a physical division of the thing owned in common when to do so would render it unserviceable for the use for which it is intended. But the co-ownership may be terminated in accordance with Article 498. Article 496. Partition may be made by agreement between the parties or by judicial proceedings. Partition shall be governed by the rules of court insofar as they are consistent with this code. Article 497. The creditors or assignees of the co-owners may take part in the division of the thing owned in common and object to its being effected without their concurrence, but they cannot impugn any partition already executed unless there has been fraud or in case it was made notwithstanding a formal opposition presented to prevent it, without prejudice to the right of the debtor or assigner to maintain its validity. Article 498. Whenever the thing is essentially indivisible and the co-owners cannot agree that it be allotted to one of them who shall indemnify the others, it shall be sold and its proceeds distrib- distributed. Article 499. The partition of a thing owned in common shall not prejudice third persons, who shall retain the rights of mortgage, servitude, or any other real rights belonging to them before the division was made. Personal rights pertaining to third persons against the co-ownership shall also remain in force, notwithstanding the partition. Article 500. Upon partition, there shall be mutual accounting for benefits received and reimbursement for expenses made. Likewise, each co-owner shall pay for damages caused by reason of his negligence or fraud. Article 501. Every co-owner shall, after partition, be liable for defects of title and quality of the portion assigned to each of the other co-owners. Article 502, superseded by Article 5 of PD number 1067, Water Code of the Philippines. The following belong to the state. A. Rivers and their natural beds. B. Continuous and intermittent waters of spring and brooks running in their natural beds and the beds themselves. C. Natural lakes and lagoons. D. All other categories of surface water such as water flowing over lands, water from rainfall whenever natural, whether natural or artificial, and water from agriculture runoff, seepage, and drainage. E. Atmospheric water. F. Subterranean or groundwaters. And G. Seawater. Article 503. The following are of private ownership. 1. Continuous and intermittent waters rising on the lands of private ownership while running through the same. 2. Lakes and lagoons and their beds formed by nature of such lands. 3. Subterranean waters found on the same. 4. Rainwaters falling on said land as long as they remain within the boundaries. 5. The beds of flowing waters, continuous or intermittent, formed by rainwater and those of brooks crossing lands which are not of public dominion. In every drain or aqueduct, the water, bed, banks, and floodgates shall be considered as an integral part of the land or building for which the waters are intended. The owners of lands through which or along the boundaries of which the aqueduct passes cannot claim ownership over it or any right to the use of its bed or banks unless the claim is based on titles of ownership specifying the right or ownership claim. Supersede Article 503 superseded by Article 6 PD number 1067 Water Code of the Philippines. The following waters found in private lands belong to the state. Okay. The following waters found on private lands belong to the state. A. Continuous or intermittent waters rising on such lands. B. Lakes and lagoons naturally occurring on such lands. C. Rainwater falling on such lands. D. Subterranean or groundwaters and water in swamps and marshes. Section 2. Article 504 and 506 are superseded by Article 3 of PD number 1067, Water Code of the Philippines, which state the underlying principles of this code are: A. All waters belong to the state. B. All waters that belong to the state cannot be the subject of acquisitive prescription. C. The state may allow the use or development of waters by administrative concession. D. The utilization, exploitation, development, conservation, and protection of water resources. Council, hereinafter referred to as the Council. E. Preference in the use and development of waters shall consider current usage and be responsible to the changing needs of the country. Article 505. Every concession for the use of waters is understood to be without prejudice to third persons. Okay. Article 507. The owner of a piece of land on which a spring or brook rises, be it continuous or intermittent, may use its waters while they run through the same, but after the waters leave the land, they shall become public, and their use shall be governed by the special law of waters and by the irrigation law. Article 508. The private ownership of the beds of rainwaters does not give a right to make works or construction which may change their course to the damage of third persons or whose destruction by the force of floods may cause such damage. Article 509. No one may enter private property to search water or make use of them without permission from the owners except as provided by the mining law. Article 510. The ownership which the proprietor of the piece of land has over the waters rising thereon does not prejudice the rights which the owners of lower estates may have legally acquired to the use thereof. Article 511. Every owner of a piece of land has the right to construct within his property reservoir for rain waters, provided he causes no damage to the public or to third person. Section 4, Subterranean Waters, Article 512. Only the owner of a piece of land or another person with his permission may make exploration thereon for subterranean waters except as provided by the mining law. Explorations for subterranean waters on lands of public dominion may be made only with the permission of the administrative authorities. Article 513. Waters artificially brought forth in accordance with the special law of waters belong to the person who brought them. Article 514. When the owner of the waters artificially brought to the surface abandon them to their natural course, they shall become a public dominion. Section 5, General Provisions. Article 515. The owner of a piece of land on which there are defensive works to check waters, or on which, due to the change of their course, it may be necessary to reconstruct such works, shall be obliged at his election either to make necessary repairs or construction himself, or to permit them to be done without damage to him by the owners of the lands which suffers or are clearly exposed to suffer injury. Article 516. The provisions of the preceding articles are applicable to the case in which it may be necessary to clear a piece of land of matter, whose accumulation or fall may obstruct the course of the waters to the damage or peril of the third person. Article 517. All the owners who participate in the benefits arising from the works referred to in the two preceding articles shall be obliged to contribute to the expenses of construction in proportion to their respective interests. Those who by their fault may have caused the damage shall be liable for the expenses. Article 518. All matters not expressly determined by the provisions of this chapter shall be governed by the special law of waters of August 3, 1866 and by the irrigation law. Chapter 2, Minerals. Article 519. Mining claims and rights and other matters concerning minerals and mineral lands are governed by special law. Chapter 3, Trademarks and Trade Names. Article 520. A trademark or trade name duly registered in the proper government bureau or office is owned by and pertains to the person, corporation or firm registering the same, subject to the provisions of special law. Article 521. The goodwill of a business is property and may be transferred together with the right to use the name under which the business is conducted. Article 522. Trademarks and trade names are governed by special law.